All right, I think we're ready to begin here. My name is Andrew Summer. I'm a partner with Conn Carey, heading up our OSHA practice at the firm. And as background, Conn Carey is a nationwide labor and employment firm with a OSHA as well as employment litigation practice nationwide. And I am pleased to be joined by my esteemed colleagues from California, Fred Walter, Megan Shaqued, and Sam Rose. We together constitute the OSHA practice in California with support otherwise within the firm. Fred Walter is a seasoned OSHA attorney practicing for over 30 years. And has particularly good insights in the present as well as historically with OSHA that he will certainly be sharing today. And Megan Shaqued and Sam Rose are our OSHA associates with considerable experience in the OSHA realm. Wanted to just cover the agenda. I mean, just to start out here, it's been a really busy year with OSHA on the regulatory front as well as enforcement. There has been a moment of change, in a way, a crossroads where the agency has been transitioning from a focus on COVID-19 related enforcement and rulemaking, and now moving towards considering proposed workplace safety rules that are outside of COVID-19. Now that the pandemic has evolved, and we're seeing enforcement focusing more on what were the traditional areas of enforcement, as opposed to a mostly singular focus on COVID-19. But during the webinar today, we have a pretty packed agenda. We've shared the slides with you. Some of the slides we'll move through rather quickly. We will leave time at the end of the presentation for questions. And if we go over, those of you that want to stay on, we'll make every effort to answer all of your questions at that time. First, at the outset, we're going to cover some enforcement trends, data on inspections and penalty amounts with OSHA. We're then going to move into the OSHA COVID-19 non-emergency rule. We had all hoped that the emergency rule, when it expired, would be the end of COVID-19 related rulemaking, but that did not happen. So we do have a non-emergency rule that incorporates many of the prior requirements under the emergency rule that will remain in effect, mostly for a 2-year period that we'll cover. We'll also address updates on COVID-19 exposure notices and reporting, and then a variety of, rulemaking issues, different rules that have been adopted and are being considered both by the OSHA Standards Board as well as legislatively. There are legislative rules related to heat illness and wildfire smoke that will be addressed today. And then lastly, we'll cover, broadly various different regulatory and legislative updates. But diving right in, I'm going to turn it over to Sam Rose, who's going to discuss the enforcement trends.
So we wanted to start with just a high-level discussion of OSHA's enforcement trends in the last couple of years. So this chart reflects inspection and violation data from 2018 through the first quarter of 2022. And as you can see, the pandemic did impact the agency's number of inspections, which in turn impacted the number of violations that it issued. But using the data from the first quarter of 2022, which you see on the top line there, we can estimate that the number of inspections and violations will be closer to 2020 levels than the 2021 levels. So like we expected, as the world slowly returns to pre-pandemic norms, the agency has also slowly started to return to pre-pandemic enforcement levels. Next slide, please.
Oh, I just wanted to, if we go back, I just wanted to raise one point is we were seeing, as many of you may be aware, is during the pandemic, there was a focus on complaint letters that were issuing. We call them alleged hazard letters that were issuing to employers rather than conducting on-site inspections because of concerns relating to on-site visits related to the COVID-19 pandemic. And so we were seeing, and I think you can see this in some of the data, where we were seeing a increased number. So if you look at 2020, you can see there's 13,000 some odd. Let's see, hold on a second. So you see on-site inspections were only 6,000 out of the 19,000. And so that's a really small number, attributed to the pandemic. Whereas you can see the year prior, that's maybe roughly a third on-site inspections, whereas in 2019, we're seeing it more split evenly. And so we are just anecdotally, we don't have all the data presently, but we are seeing that there's more on-site inspections going into 2022 and into this year.
So this chart reflects industry-specific inspection and violation data. This is all from the first quarter of 2022. And this is for some of the industries that received the highest attention from the agency. Just want to give a little bit of context based on the prior year. So the 429 inspections in construction is 38% higher than the first quarter of 2021. The 238 inspections in manufacturing is 22% higher than the same time in 2021. The 55 inspections in wholesale trade is 38% higher. The 100 inspections in retail trade is 30% higher. And the 98 inspections in agriculture was the only one that actually went down, only by 2 from 100 during the first quarter of 2021. So this chart just kind of reflects the agency's ability to conduct enforcement, like we explained in the last slide, is slowly increasing as the world returns to normal after the pandemic. The agency's penalty cap is also slowly creeping higher. While the serious and failure to abate penalties have remained the same over the last couple of years, you can see that the potential penalty for general and regulatory violations is more than double what it was in 2016, from 7,000 to over 14,000. Also, the penalty for willful and repeat violations have gone up significantly from 70,000 in 2016 to over 140,000 in 2022. So just another example of the agency being able to issue higher penalties as time has gone on.
And I just want to add to that the Cal OSHA penalties have been historically high for serious citations, as well as for failure to abate. But it's the willful and the repeat and the regulatory general that, as you can see here, in 2016, the maximum for regulatory citation was 7,000, and for willful and repeats, that was 70,000. And the reason why you see a significant jump here in 2017 was that Fed OSHA revamped its penalty structure, and because Cal OSHA has to be at least as effective as Fed OSHA, we saw legislation in California the next year to increase the penalties in these areas. And so that did not take effect until the prior year in 2017. And then we've had consumer price index increases thereafter. And Sam will discuss the latest development with Fed OSHA that will invariably impact Cal OSHA.
So this chart shows the potential penalties under Fed OSHA for the different categories of violations. And like Andrew just explained, California as a state plan has to be at least as effective as the Fed OSHA plan. So if you look at the numbers for 2023, based just on the consumer price index in Fed OSHA, those penalties are higher than the current Cal OSHA penalties. So we expect the Cal OSHA penalties will increase in order to remain in line, at least, or greater than these Fed OSHA penalties. So just the moral of the story with this data is that Cal OSHA is beginning to conduct more inspections. They're armed with higher potential penalties for violations. And there's really no expectation now that either of these trends will reverse course anytime soon. But that I'll turn it over to Fred to talk about more updates.
Here I am. Thank you very much. So the current state of OSHA is in flux. They have lost a lot of people, as so many agencies did, so many employers did during COVID. Their vacancy rate currently is 23%, as you see there. They have a number of positions left to be filled. They still have 4 districts without managers, and their total efficient, or the vacancy rate in the legal unit, that is the number of attorneys that they can throw into battle over appeals, is 58%. That was in 2022. They since have had a spurt of hiring, but we find that the attorneys that they hire in, of the attorneys they've hired in to take up the slack, something in the range of 20 to 25% have taken a look around and decided they want to work somewhere else and gone. So in some of our appeals, we're now on our 3rd attorney, and the 3rd attorney is always trying to look for the 2nd or 1st attorney to find out what they should be doing. It causes a little frustration on our part, but everyone's going to muddle through it somehow. Next slide, please. So the appeals board is no stranger to the attrition from the COVID crisis. They lost a number of their staff. None of the judges left, although the judges who left because of COVID, but those who did retire have only slowly been replaced. We're finding that status conferences, settlement conferences, and hearings are being set at least 3 to 5 months out. So we have time to prepare. Nobody's turning us around quickly. BOI is an interesting, has an interesting status in California. The Bureau of Investigations is that branch of Cal OSHA which is responsible for investigating death cases and other cases to see if criminal charges should be referred to the local DA. By a quirk of budgeting and legislative ineptness, the inspectors who should be in BOI, who should be more competent and more trained than the COSHOs, are paid at a rate about 40% of what a COSHO is paid. Hence, failure to or an inability to hire into BOI. So that we have Northern California with 3 positions available and only 1 is filled. And in Southern California, there are 5 and there are 3 positions filled, which means a lot of cases are not being inspected or investigated, which is a good thing for us. While we're talking about the board, they have been busy. There are 3 cases I want to talk to you about. The first one is Shimmick Construction. And their classification as, well, first of all, under 6432 sub O of the Labor Code, for a COSHO to qualify as an expert and therefore able to testify as to whether a citation should be serious or not, they have to prove that they're up to standard in their training. It used to be that you could go in and prove that they had not been fully trained and they would be incompetent to testify as to classification. But this decision found that there are many other bases for determining whether a COSHO can be qualified as an expert on classification. Among those is expertise in the subject matter, experience working in the area covered by the regulation. And finally, the board said that if you fail all of those, you can rely on common knowledge and human experience. Just sort of, yeah, I think it feels right that this is a serious citation. So there's no need anymore to worry about proving a COSHA's training under 6432O. Second case I'd like to mention is Rios Farming. Just recently held that the heat illness section on water, section 3395C, and that bothersome language as close as practical. They finally come up with a definition of it. It's not so much the distance between the water and the employee, but it's the availability of it such that it encourages drinking. This case involved field workers in a wine, in the wine fields. They were pruning the vines, and they were working in rows. And some of them were working in rows, row 1, row 2, row 3, 4, row 5, and the water was in row 3. So for the people in row 1 and row 5 to get to the water, they would have to traverse the trellises holding up the vines to get in there. And the judge said that having to stoop and bend and crawl through vines to get to water is not as close as practical, even though it was closer than water that was set at the end of the row. The appeals board agreed with that, and from that we get the case name. Somebody just asked what was the case name. The case name is Rios Farming, and if you send me an email, Ms. Clark, I will be happy to send you a link to where you can read the case. The other part of the case that's interesting to us is how you identify a repeat. And here the board agreed with the ALJ that a repeat doesn't have to be identical in circumstances to the earlier citation. It's enough that it is based on an earlier settlement, and that's the interesting part here. It was a settlement. Who knows what might have happened if you'd gone to a hearing, but a decision was made to settle. Working conditions were similar in that they were field workers. The hazard of lack of water was the same. And the abatement was different. Well, it didn't matter that the abatement was different. The repeat applied where the hazard was the same and where the working conditions were similar. That's a new test that we're going to have to struggle with as we go forward with our defenses. The third case I'd like to talk about is Teichert and Sons. This raises the hair on the back of all defense attorneys' necks. After a hearing was done, after all the evidence was in, and it was thought that the case was going to be submitted for a decision by the ALJ, the division moved to amend to state a totally different regulation. They didn't feel that they had proved the allegations of the citation as written, but they did feel that they proved that there was a violation of this other regulation that they wanted to introduce. The ALJ said too little too late, no. And so the division filed a petition for reconsideration. The appeals board looked at it and they said, yeah, that's okay. You can do that. Facts are close enough. And so we're going to grant the petition. The new regulation will be the one applied to the employer. And we really don't feel it necessary to have any hearing on this. So we approve not only the citation as rewritten and the penalty, but there you go. So your next step is the Superior Court on a writ. This case has gotten up to the Court of Appeal, District Court of Appeal. It's pending hearing. But the galling thing about the appeals board's rules is that once a petition for reconsideration has been decided, that's the rule that the board will apply going forward in other cases. you cannot request a stay of the decision pending appeal to a higher authority. So everyone has to live by Teichert and Sons until the Court of Appeal tells us whether we are bound by it or not bound by it. And that pretty well does it for me. I want to hand it back to Andrew, who will start on the COVID rules.
Thank you, Fred, for those case insights. There's been quite a bit on board decisions this past, actually just a few months, it seems. I'm going to address the Cal/OSHA COVID-19 non-emergency rule. Just when you thought the COVID pandemic was waning and rulemaking in that space was over, we have the non-emergency rule. This was fairly controversial, as you can imagine, and there was extensive discussion before the Standards Board on this rule. And so we've, we'll cover this a little bit later in the presentation, but we lead a employer coalition on Cal/OSHA rulemaking. We were very involved in advocating over the COVID-19 emergency rule. And, we also served on the Cal/OSHA advisory committee over the rule. And so we followed it closely. It's like whiplash a little bit because there's been so many different versions of the emergency rule. And now we have the non-emergency rule, and in many ways it's the same as emergency rule. There are some material differences that I did want to cover. So it's important to be aware of this non-emergency rule and its compliance obligations. This rule took effect February 3rd of this year. It will remain in effect for all intents and purposes for 2 years, except for record-keeping purposes. And so there is some guidance from DOSH in the form of fact sheets and FAQs. There's a model COVID-19 prevention program that you don't need to use. You can develop your own, as we've done with clients. But let's just dive in to some of these really kind of material differences. There's some, less significant ones, but I wanted to cover the more major changes that we've seen. One was prior to the adoption of the non-emergency rule, there was a public health order by the California Department of Public Health that redefined the definition of close contact, which caused us great bewilderment because we had this tried and true standard of the 6 feet rule that was adopted by CDC and thereby by Cal/OSHA, and all of a sudden they came up with this new standard. And the rationale for the new standard was that they've determined that COVID is an airborne disease, and we've known that, but it didn't really explain why they changed the rule. And so the rule was changed to take out the reference to 6 feet distance for the purpose of determining a close contact, instead referring to workers that are in the same indoor airspace. It still contains reference to 15 minutes or exposure over a 24-hour period to essentially a COVID-19 positive case. But what happened was the initial California Department of Public Health order just removed that reference to that 6 feet of distance, regardless of the size of the workspace. There was great kind of consternation, not just by the regulated community, but also by organized labor and agency members on the Standards Board. As a result, there was a tweaking of this. And in our comments that we submitted during this rulemaking process, we pointed out, concerns over large workplaces, such as a warehouse, distribution center, large retail store, grocery store, where, effectively making everyone a close contact was just not manageable. And there really were no metrics for indicating what the same indoor airspace really means. But as a result of the comments that were made, whether by us or collectively, there was a change to this definition is incorporated in the non-emergency rule. So there's this division between workspaces that are 400,000 square feet, cubic feet per floor, or those that are greater than 400,000 cubic feet. And just as background, when you're calculating the cubic feet, I mean, I don't have a mathematical background by any means. I went to law school, but you're essentially taking the floor, the distance, the length and the width and the height, and you're multiplying them together. So the higher the workspace, the more cubic feet you're going to have, which is often the case in a warehouse, for example. So if you have a workspace 400,000 square feet or cubic feet or less, you're going to fall under this new definition of same indoor airspace. But if you're larger than that, you fall under the traditional CDC 6-foot rule. So that was a good outcome for the larger workspaces. I recognize for those workspaces that are smaller, this is going to continue to cause concern because there hasn't been really any, meaningful guidance from DOSH on this term. And then when you're looking at same indoor airspace, you're really talking about sealed off workspaces. So if you have offices, suites, waiting rooms, break rooms, but if you have one very large room, such as in a smaller warehouse, it's going to be a little bit of a predicament in determining what the same indoor airspace actually is. So let's move on to some other issues as well. We do know that, when the non-emergency rule was being considered, there was concern by the administration in how onerous the emergency rule was, and that it was many pages and contained considerable detail that not only the regulated community, but the agency had difficulty interpreting. So there were some efforts to at least try to streamline the language, and one of them was to remove all the detailed enumerated elements from the COVID-19 prevention program requirement. So, you still need to have COVID-19 procedures detailed either in your IAPP or in a COVID-19 prevention program, but you're not required to have the same detail as was required previously. And then also on training topics, you're required to train on COVID-19 consistent with your IAPP, but there is no requirement to cover training per all the enumerated elements that were previously listed in the emergency rule. And that's an important change, because we were finding during the pandemic, employers were being cited for having COVID-19 training, but not covering a single topic that was listed under the rule that may not have been all that meaningful for that given workplace. So let's move on then. There is a real significant change is the removal of exclusion pay. This was a highly contentious issue, and there were certain members of the Standards Board that were lobbying for the inclusion of exclusion pay. And of course, most employers were concerned about its inclusion given the potential for abuse by employees, among other, obvious financial concerns. And so it's no longer in the non-emergency rule, but the Standards Board is chomping at the bit to include exclusion pay in a permanent infectious disease that's being considered. So stay tuned for that. But in terms of the non-emergency rule, even though there is no exclusion pay under the OSHA rule, there is a requirement to provide paid time off for employees to attend to their own health concerns under state and local paid sick leave laws. Of course, there's a cap on those, and there's a limited accrual, unlike what we've seen under the OSHA rule. And it's important to note, even though there is no exclusion pay, employers are still required to exclude employees that test positive for COVID-19 and follow these kind of strict return to work criteria. And I think we can move on to the next topic, which is the change here is really regarding the new definition, return case, employers continue to be required to make COVID-19 tests available at no cost during paid time to all employees who had a close contact. But the exception is for employees are considered a return case. And previously, there was an exception for employees who had tested positive for COVID-19 90 days prior or developed symptoms 90 days prior, but that has been changed to a 30-day time frame. And it's not entirely clear to us why they limited this to such a short duration. Okay, so next on the list is the issue of face coverings and respirators. There, during the emergency rulemaking process, at one point during a modification, there was a removal of the requirement that employees wear face coverings in the workplace, except to the extent that they're mandated by public health order or regulation. So that continues to be the case. There is no requirement for employees to wear face coverings, except if there is an outbreak. And then there's certain requirements that may be triggered for the exposed group. And then employers may not prevent any employee from wearing a face covering unless it would create a safety hazard. So it's really at the election of your employees whether or not they wear face coverings. There is a requirement that was added in on the requirement that employers provide respirators, essentially N95 masks, upon request to employees for voluntary use. It's important as a result of this requirement that employers have on hand a sufficient number of respirators should there be a need. And there's certain ways that we've advised on how to tackle this if you're concerned about stockpiling and also ensuring that you don't run out of those respirators. But let's move on. Ventilation. This caused me to be somewhat perplexed because there is a prohibition on underground regulations, meaning that a Cal OSHA cannot require an employer to rely on enforcement guidance that's evolving. And if there is a requirement, a specific mandate, it needs to be set forth in the rule itself. But they did draft this in a way that I view as unenforceable, where they were requiring that employers follow guidance from the division that they're describing as interim guidance for ventilation, filtration, and air quality in indoor environments for determining whether the ventilation system is adequate. And so after reviewing that guidance, employers are then required to implement one of three different ventilation modifications based on COVID-19. But let's just swiftly move through. There's just a couple of other areas I wanted to cover. A significant change is there's no longer a requirement to document close contact, but you still must track and essentially create what we call a shadow log of COVID-19 cases with the name, contact information, and other pertinent details that are listed here. And I believe you have a copy of the slides, so I won't go through all the detail. And then regarding the documenting of close contacts, we do recommend documenting those close contacts as best practices because oftentimes with Cal OSHA, if you don't have a document, you just never did it, what you assert that you did according to Cal OSHA. So even though it's not expressly required, it is something that we'd recommend as best practices. There's also a 2-year retention period generally for records. And then I think we can move through. I don't want to get bogged down too much in the non-emergency rule. So I just wanted to make the point that we still have outbreak and major outbreak provisions in the non-emergency rule. And to me, that's the most frustrating aspect of the non-emergency rule, because we clearly are not in the circumstances that we were in early in the pandemic. And it is more likely that you could have an outbreak with no one, becoming seriously ill, or where you don't know whether certain individuals actually are positive, and you could have a fairly large workplace. And so the threshold for triggering a simple outbreak is only 3 or more COVID-19 cases in a 14-day period, and that's an exposed group. But that's still a fairly light trigger point. And so the one change that was made, that it is no longer a requirement that you have no COVID cases to get out of this outbreak cycle. Now you have to have 1 or fewer COVID-19 cases detected in a 14-day period. So it's a modest modification. And then you have a number of requirements over testing and face coverings and respirators that remain the same. And then you have fairly similar requirements for major outbreaks, and that's where you have 10 or more COVID-19 cases in a 30-day period. So let's move to the next slides. And, I'm going to pass on the employer provide housing and transportation requirements, as I don't expect them to be relevant to most of you. But if you have any questions on those, certainly reach out. And now I'm going to turn it over to, is that you, Megan, over a COVID-19 update?
Yep. So there's one other aspect to the COVID-19 update that's stemming from labor code sections as opposed to the non-emergency rule itself. And that is, I'll give you a little bit of context. So the non-emergency rule, in terms of notice of COVID-19 cases, requires notice of close contacts. But the non-emergency rule defers to existing labor code section when it comes to notice, the more general notice of potential exposure. And if you remember back to early days of the pandemic, when there were concerns that employees may not know of a positive case in the workplace, the California legislature passed a requirement that employers notify employees and certain other workers that they were present at the workplace while a positive case was there during that infectious period, so that they were potentially exposed to a positive COVID-19 case. This section, this labor code section that required written notice of potential exposure, was set to expire January 1st, 2023, but it was extended 1 more year, and it remains in effect until January 1st, 2024. There has been a slight update to it. If you recall, these were very cumbersome notices that had to be provided within 1 business day in writing, usually via email or even mail. And so they have eased the burden a bit on employers who want to take advantage of a posting requirement. The written notice can be posted, but there are certain additional requirements that must be complied with. The postings have to be posted for a certain amount of time, and employers have to maintain a log of those postings. There's also some additional requirements about the language that the postings have to be in. And then another key update to this labor code section is that traditionally all outbreaks had to be, employers had to notify the local health department of all outbreaks. That requirement stemmed not only from the emergency temporary standard, but also this labor code section. The notice of outbreaks has been removed from the labor code section. So now the only reporting requirement that remains is through the non-emergency rule, and that is only applicable to major outbreaks. So major outbreaks must still be reported to the local health department under the non-emergency rule, but general outbreaks or minor outbreaks no longer need to be reported. There has also been a corollary labor code a few labor code sections that were passed that have to do with workers' compensation coverage of COVID-19 cases. This piece of legislation was also set to expire January 1, 2023, and will likewise be extended 1 more year to January 1, 2024. So the existing requirement that you're all familiar with, where there is a rebuttable presumption of workers' compensation coverage for employees who contract COVID-19 during a workplace outbreak, that continues for another year. And the requirement that COVID-19 cases be reported to your workers' comp claims administrator will again continue for 1 more year. So for the next little bit of time, we're each going to spend some time updating you on kind of other regulatory and legislative updates that have come into being or are in the pipeline that are not related to COVID-19. So the first, I just want to flag, we discussed AB 2188, which has to do with employee protections for cannabis use. We discussed this piece of legislation in great detail during our Labor and Employment California update. And we provided the full slides here, so you have the full context, but we wanted to just flag this during our OSHA update to the extent that employers have a testing protocol in place, either pre-employment testing or post-accident testing. You'll want to pay particular attention to this new piece of legislation. It changes the landscape fairly dramatically in California. And it passed last year, but it does not take effect until January 1st, 2024. There is a recognition that this is a pretty significant change. So over the last decade plus, employers have been allowed to require pre-employment drug testing for marijuana use. And there was even significant protection to refuse to accommodate a disabled employee's use of marijuana. Assembly Bill 2188 now makes it unlawful for an employer to discriminate against employees or applicants based on either their individual use of cannabis off the job and away from the workplace, and based on employer required drug screening tests that tests for non-psychoactive cannabis metabolites. And non-psychoactive cannabis metabolites are in contrast to active THC. So essentially, the law prohibits employers from relying on tests that measure for these non-psychoactive cannabis metabolites, which can be present long after use of marijuana, as opposed to tests that might be geared towards testing current use or active impairment. So we expect, given the delay in the effective date of the legislation, that there may be changes to what's available to employers for marijuana testing, but this is something that employers who do have a protocol for this will need to pay particular attention to. There are some limits to the new law. It doesn't prohibit pre-employment drug screening, but since it limits what you can rely on and what you can use the results for, there may be some limited value in pre-employment drug testing. Post-accident testing is a little bit different. There are also some specific carve-outs for employees in the building and construction trades, and for positions that require federal government background checks or security clearances, but we realize that those are limited carve-outs based on employers who may need to use post-accident testing or other testing protocols. And with this, I will pass it over to Sam.
So Cal OSHA already has regulations covering both heat illness and wildfire smoke. But nonetheless, the California legislature passed AB 2242, and the governor signed that bill, which requires the division to promulgate standards related to these topics. So more specifically, AB 2243 requires DOSH to develop a proposal that would require employers to distribute their heat illness and prevention plans to their employees at least once a year. We've noted that this seems unnecessary based on the current standard requiring that the plan be available at the worksite. But this is just another example of the California legislature capitalizing on the opportunity to regulate employers. 2243 also requires DOSH to submit a proposal that would require employers to provide respiratory protection and require employees to use that protection when the AQI for PM 2.5 is greater than 301. The current regulation requires employers to provide respirators for voluntary use when that AQI for PM 2.5 is anywhere between 151 and 500. The frustrating part about this directive is that there's absolutely no rationale given, scientific or otherwise, for why the standard would need to change to these numbers. So these are just two directives from the legislature to DOSH that you'll want to be aware of, because they're eventually going to have some changes to these two standards. Next slide. So AB 257 creates what's called the Fast Food Council. The law was actually stayed by the courts from going into effect on January 1st, 2023 as planned. A referendum to repeal the law is actually expected to be on the ballot in November 2024. So this bill isn't in effect. It probably won't go into effect for a while if it does at all. That said, it's just good to note that this is another example of the California legislature's trend of regulating specific industries through legislation. The law allows the council to establish minimum standards, and those minimum standards include wages and, quote, the working conditions adequate to ensure and maintain the health, safety, and welfare of workers. So as the slide says, the council is not authorized to promulgate workplace safety standards, but they can petition the standards board to adopt or amend or replace any occupational safety or health standard. So it's likely that if this council does get created, that it could become a big influence in advocating for changes in workplace protections specific to fast food restaurant workers. And it's also likely that if this council gets created, well, not likely, but possible that if this council gets created, that the legislature could do similar types of councils for other industries. With that, I think we'll pass off to Fred.
Thanks, Sam. As Sam pointed out in the last few slides, the legislature is becoming more and more active in directing OSHA as to what to do. And the fast food council is rather frightening because it creates an entire new bureaucracy, an entire new police force, which is, as Sam pointed out, could be replicated for any industry that falls under the gaze of the legislature. What I want to point out to you now is another expansion of OSHA's jurisdiction through the legislature. They are required to now take a look at whether they should be regulating household domestic workers. The law would remove the household domestic services exclusion from workers' comp coverage. It would apply the IIPP and by extension all other regulations in Title VIII to homeowners who hire domestic work. And this is not directed simply at homeowners who are rich enough to have live-in or daily domestic work. There's no exclusion for homeowners who have someone come in once a week. And so this is really an interesting bill. It moves OSHA into our homes for the first time. You'll recall that OSHA has decided that they cannot regulate home offices, even if you're working remotely for a large corporation. They stay away. But not this time. Next slide, please. Labor Code Section 6318 also now requires DOSH to identify the top 7 non-English languages used in California and Punjabi, and then make the forms that are required to be posted after a citation is appealed, posted in those languages, if any of those languages are spoken in the workplace. employers so they have to find in the next couple of years or the next year, they have to find translators first of all, they have to identify the top 7. Then they have to find and hire translators to do the translation. Then they have to do the printing, and then they has to be available. Those forms will not be sent out from the appeals board with every notice of docketed appeal. Employers are going to be responsible for identifying the language that is being spoken in the workplace and asking for the specific forms applicable to those workers. There are a couple of other things that I'd like to talk to you about. By the way, this Labor Code section 6318 should be looked at in comparison to 6409.6 that Megan was talking about as to outbreaks. Notice of outbreaks have to be posted in English and the majority language of the workers. This is different. If you have one person in the workplace speaking Hmong, you're going to have to get a translation of the notice in Hmong to post. But there are a couple of other things I'd like to mention that aren't on the slides. First of all, we have Senate Bill 553 from Senator Cortese in San Jose, which directs the division and the standards board to establish a workplace violence standard for all workplaces and all industries. That's something that is supposed that the purpose, I suppose, to this is to goose the division into working on what they're already working on quicker. It's interesting to note, and I've been around long enough to remember this, but back in the early 80s, then chief of Cal OSHA, John Howard, and his deputy, Len Welsh, who later became chief, worked for years. We had innumerable conferences and workshops and the like, trying to develop a workplace violence safety hazard. Workplace violence standard for all industries. And John, who has every degree known to man, one of the smartest people I've ever met, and Len, who's no slouch, they simply couldn't do it. They couldn't get all the pieces together and come up with a coherent program to advise the standards board to adopt. And so far, this iteration, this go around, the division has been working on this for, I believe, 2 years now, and hasn't come up with something that they think is appropriate. So we'll have to see how far they can go in complying with Senator Cortese's requirements. And then we have something on the brighter side. Just today, there was a bill introduced in the Senate, Senate Bill 375, that would provide a compliance credit in tax years 23 and 24 to employers, tax credit to recoup some benefit from the money spent to comply with Cal OSHA's COVID rules. This is a matter of too little, too late, but it's nice. The other thing I'd like to mention, and this is off topic, but I think was very curious. There is a new study out of the United Kingdom that found that, and a major study, and has been given play in the papers. You may read about it today. That masking during the COVID crisis had no effect whatsoever on transmission rates. I don't know that will be persuasive to any of our rule makers here in California, but there you go. And with that, let's go to the next slide. And turn it back to Andrew.
All right, want to just briefly discuss some of it's actually, well, it says DOSH rulemaking, it's actually the Standards Board rulemaking. And we've had really a lot of energy expended in COVID-19 rulemaking over the last couple of years, such that many other rules that were even proposed way back when have been on the back burner. Now that the non-emergency rule has been adopted, we anticipate, first of all, there being a general industry permanent infectious disease standard, and proposed. We expect that draft to release soon, and that from what we've heard from DOSH, which is drafting the rule, is that we expect that they're going to include exclusion pay at the urging of certain members of the Standards Board, and so it will be another battle that will be waged over that. It's also unclear exactly what that standard will look like. Is it going to be similar to the aerosol transmissible disease standard for healthcare? That is my suspicion, but it's unclear yet exactly how that rule will be worded. We just learned that the lead in construction general industry standard is slated for public hearing in April. That's the last word. I mean, some of these dates can be changed, of course. So we should be getting the latest draft of that rule soon for public comment. We also expect in May for there to be a draft of the indoor heat illness prevention standard. That proposed standard has been kicked around for many years, and now it looks like it may be moving to formal rulemaking process. And those of you in certain industries like your restaurant and other work environments where you can have higher heat conditions, where there may be issues with how you mitigate that, are going to find some concern with this new rule, and that's something that we will continue to advocate over. And then there's the medical services and first aid kit standard that is or has been considered in various different drafts. We expect there to be a further draft that will circulate soon. Otherwise, a major standard that has been considered for a while, and we just don't know when the draft will issue, is over workplace violence for general industry, which is somewhat patterned after the workplace violence standard for healthcare. And, you know, there are many in the kind of labor and affiliated groups that have really been pushing for more aggressive rulemaking by the Standards Board, and they have limited resources just like any other state agency, and I think the agency is moving fairly swiftly, but there's been really efforts to get them to adopt certain cherished or kind of pet rules on a shorter time frame. And so we just learned the other day that there is legislation that's being proposed by the California legislature to essentially mandate the workplace violence standard. And we'll see what happens with that. I think they're overstepping their bounds. This is really within the realm of the Standards Board, and they just need to adopt a rule in due course to ensure that it's the most effective and manageable rule possible. But I think we can move to the next slide, which I think concerns our rulemaking coalition. We will be having a kickoff meeting of our 2023 Cal OSHA Rulemaking Coalition. Our last coalition was focused on COVID rulemaking because that was all encompassing. Now there's going to be many more rules on the agenda, so it's a broader based coalition. And like with the COVID-19 rulemaking coalition, we will be assembling a group of employers and various different trade organizations to discuss the different rules on the agenda and develop a game plan for what comments we will submit, and basically incorporating the concerns of employers and giving real life context that will hopefully favorably guide the rulemaking process. And so, as we indicated, the permanent infectious disease standard is on the agenda, as well as lead standard, indoor heat illness, and workplace violence. And those of you who are interested in joining the fee-based membership can just send me an email. The contact information is at the bottom of the slide. And I think that now ends the presentation, and we can answer some of your questions. We did want to share our OSHA webinar series. We always have a Cal OSHA enforcement and regulatory update towards the beginning of the year, but there's many others with issues that would be real relevant for California employers. And then we also wanted to share our MSHA webinar series. And then we have blogs that cover regularly updates in the OSHA as well as the employment litigation realms that you can review on our website. And you can also subscribe by entering your email address and receive timely updates as we post. But wanted to now go through some of your questions. For those of you that asked questions a while ago that are tailored to certain portions of the presentation, we might not be able to decipher those for this purpose. So if you want to retype them, we can answer them now. There was one question about, there was a question, does the cannabis law affect DOT safety sensitive positions, fleet transportation drivers, someone working on pipelines? Did someone want to answer that?
Yeah, so I mentioned that there are some carve-outs to the law, but they're fairly narrow. And we recognize that there's other industries that are impacted by this. And since it is a brand new piece of legislation, and as we've seen with new pieces of legislation in California, sometimes there are kind of follow-up pieces of legislation that clarify things, but this is definitely going to take some time for employers and us included to kind of figure out what this means for employers who are impacted by this and have a need for continued, particularly post-accident drug screening, and how that they're going to continue to do what they need to do and be in compliance with this new law.
And there is a carve out for Department of Defense mandated positions, and also for construction industry positions. But there should be a carve out for safety sensitive positions. And so that was the first thing that stood out in my mind, and it is a real concern. So, I'm hopeful that there are further carve outs, but presently you're fairly limited. Okay, and there was a question about what the current isolation requirements are for positive cases in the workplace, and I can answer that briefly. This information is available. There are FAQs on DOSH's website that I think are fairly helpful that talk about the exclusion requirements, and they are evolving. And so as there's new Department of Public Health requirements, they could change. So, but presently, a COVID-19 case, essentially someone that tests positive for COVID-19 must be excluded from the workplace for at least 5 days after the start of symptoms or after the first positive test with no symptoms. And then they may return back to work after day 5 if symptoms are not present or are resolving, and that they have to wear face coverings for the remaining days at work from day 5 through day 10. But if an employee is experiencing symptoms, they should not, or they continue and are not resolving, the employee should be excluded from the workplace for the full mandated 10-day period.
Andrew, if I can jump in for a moment.
Okay.
There was a question about one of the things I covered in my presentation, and that was the mandate that Cal OSHA create notice forms in the top 7 languages in California. And the question was, does the employer have to do that? No. The requirement is that Cal OSHA has to determine what the 7 most prevalent languages spoken in California are, and Punjabi, and then create the forms themselves. And then the employer's obligation is simply to identify those in the workplace who are more fluent in one or more of those languages than they are in English, and then ask the division to provide those forms for them to do their posting. I hope that answers the question.
And let's see, maybe we can find one more question here.
I think while you're looking, Andrew, I think there was a question about the notice of potential COVID-19 exposure. If you're keeping the logs of postings rather than providing those notices via email or mail, how long to keep those? They are being treated like employment records, like wage records and things like that, that need to be maintained for 3 years. They are supposed to be made available to the labor commissioner. And so they're treated like similar records and have to be maintained for 3 years.
Okay. There was a really good question about if an employee provides respirators, will the employer need to annual fit testing and a written respiratory protection program? And if you look at the standard under refers to the respiratory protection standard. And so essentially under the non-emergency COVID rule, there's a requirement or that employer must provide respirators for voluntary use upon request, but it's not considered mandatory use. So that's an important distinction in that there is the handout that you need to provide, and it does mandate training, but you're not required to provide a medical evaluation and other onerous requirements that you would have if it were a mandatory use. All right, I think that will conclude the presentation. We'll try to circle back if there were any questions that we weren't able to answer. But certainly follow up with us if you do have any questions. And we would, love to be a resource in Cal OSHA as well as the OSHA space. We live and breathe this. And if you have any needs in this area or simply want to reach out on the issues that we discussed today, you have our contact information on the slide. Thank you for attending.